recording to the cloud.
Oh,
We're ready to go.
all right. Thank you, Deborah.
Yes.
Afternoon, everyone. This class is about how to transactions during COVID 1 year later, basically, because I've been getting so many questions about, well, we're in the red zone, so that means we can do open houses, right? No. We can we can door knock, we can drop things off. No, nothing has really changed for the real estate industry. Just because we've moved from purple, which was really the top of the tiers, to the red, and probably we won't see a difference. My guess is 2 more tiers. We're saying maybe by summer, early fall. So if things keep going the way they're going and more people get vaccinated, I had my second one today. So so more and more people are getting vaccinated. I saw so many young people getting vaccinated. I don't know how they're doing it, but they are. So anyways, so what does the transaction look like now? It really is kind of really the same. I'm going to share my screen because you should know what you should be looking at my zip forms. Is that what we're seeing, Deborah? Yes, I see you. Okay. Okay. So I keep moving myself here. Wait. Sorry. I have mine and Deborah's face everywhere I wanted to click on. So all right. So this is your zip forms library. For those of you who have converted over to Glide, it won't be configured this way, but this is our forms library. And when you first open your forms, wait, I'm going to go back so you can see that. Sorry. This is your dashboard. You go up on your dashboard, it says forms. It's going to bring over this forms libraries. And if you look, there are a whole bunch of libraries there. I have more than most because I belong to so many associations that all their individual addendums and all of that. You see South Bay, you see Southland, Bakersfield, Citrus Valley. They're all there. All their individual addendums specific to their associations are in mine. If you're a member of SRAR, Southland Regional, you'll have a Southland Regional. These are all your forms libraries. So, but at the top is the California Association of Realtors, which are your zip forms, which are the forms that our state association puts out. And they do 2 updates a year with either new or revised forms. And it is in June and it is in December. This December, it is going to be the new RPA. It's going to be different. So I'm kind of not teaching RPA anymore because it's just going to change. And as soon as they start training people, I'll take some training and then I'll start teaching it, the new one, up to 15 pages, I believe. So just so you have that. So so these are your zip forms, and if you're looking, we're looking at all of the forms in the California Association of Realtors. Now today we're talking about COVID. What do you need when you're doing a COVID transaction? So I'm going to tell you a little trick here. You see it says A to Z. It also says all. Well, you're going to pull that down, that thing down, and you'll see here COVID sales. We're going to talk about sales first, and if we have time for leases, then we'll get to that. But COVID sales, these are all the forms specific to COVID when you're doing a sale. So the first thing you would do if, say, you have a listing. So let's look at the listing agreement coronavirus addendum. So that's the first thing we're going to look at. So this is an addendum to your listing agreement. Everyone should be using this coronavirus addendum when they're taking a new listing, because it informs your seller about the coronavirus, and it gives you some permissions that you what you can do and what you can't do. So the top of it is the usual that we're talking about. This is an addendum to the listing agreement dated regarding the property, and it's between the broker, not between you, the agent, it's between the brokerage, so whatever office you're with, and the seller. Now, once again, if the seller is a trust or an LLC, the trust or LLC can't sign documents. You need a different form, and I think it references that a little later. But if I have time, I'll go over it because it's a little confusing now, and that will be straightened out in the new RPA. So, anyways, so the first big paragraph right here, it just talks about the coronavirus, and and the very important thing that's in bold: brokers and agents will comply with COVID-19 directives. And what are the COVID-19 directives? When I started this class, I said, well, we moved into the new tier, and what does that mean? What does that change? Well, those are the Cal OSHA guidelines that the state has put together in order for us to do our job, basically. Those are the directives. So we as agents and as brokers, we are abiding by those directives, and failure to abide by those directives can get you in trouble with the law. I mean, that's just the bottom line. Has nothing to do with CAR. They're not putting these things together. It is the state and local ordinances are dictating how we can do our job. So don't blame it on CAR. Don't blame it on your local association. These are guidelines from the state. Okay. So the first thing is property showings. Now the seller agrees to allow prospective purchasers to enter. Now there's a box that says he does not agree. Seller can say, I don't want anybody in my house. So that will present a problem, because you really can't market it, but it is possible. But if the seller agrees, then this next one, this box is already checked that they're going to sign a PED-S, and that is allowing showings to happen on the property. So what if it's tenant occupied? Well, your seller has to sign this, a PED-S, to allow showings, and the tenant has to sign a PED-S to allow showings. Both of them have to sign. If the tenant doesn't sign, you can't show it. That's just the bottom line. Then the next question is, can the seller evict them because they are not allowing showings? So the answer to that is a blatant no. You can't force somebody to put their health at risk. If they're truly uneasy about people going through the house and it is tenant occupied, then unfortunately that house can't be shown. So that is the first paragraph. And then B to that, I have been getting a lot of calls about this, because a lot of people are saying, well, I represent a buyer, and the seller's agent is telling me that I have to show proof that they are approved before they'll even show it to me. Guess what? This little box, if it's checked, that's actually saying to the to the listing agent, before you let anybody in this house, I want to see proof that they can afford, they're pre-approved. Show me the money, show me the proof of funds. If it's a all cash deal, that is a requirement to see the house, and the seller has instructed them that they need to get this information. So be aware of that. The second part of that is they represent that they have previously viewed the property online. I mean, that's easy to do. Okay, so going on to marketing activities, number 2, it just says, hey, we're going to do all these, we're going to market this. We're going to take pictures, we're going to install a sign. The seller can limit what he wants you to do to market the property. If he says, I don't want you to take photographs, then you can't take photographs. But MLS says that you have to include at least one exterior photo on a listing. So just be aware of that. And then post acceptance, this is what, hey, Mr. Seller, this is everything that I'm going to do. Once we get an offer accepted, people are going to be in here to do an inspection. They're going to do an appraisal. All of this stuff is going to happen once we have an acceptance. And if, once again, there is a box that that they can check to say, hey, I don't want you to be doing that. So, and it talks about paragraph 4, which is on the next page, and that seller prohibiting or limiting access to the property. And it's basically saying, hey, Mr. Seller, you're fine if you want to limit our access, but you may not get as much for the money by limiting the access. It may be necessary to modify any real estate agreement entered into by the seller and the buyer. If you do so, and you probably, if you're going to modify it, you should seek the advice of your own attorney. So that's what paragraph 4 is. So property and showing rules, it talks about what the rules are and what Cal OSHA, there's that word, Cal OSHA, have issued these directives about real estate transactions. Remember, a year ago on the 19th, when we were shut down, we were not essential services. We all had to sit at home. And it took a couple of months for our representatives at CAR and at our local associations to talk to our lawmakers, to talk to the governor and say, hey, we're essential services. We need to work. And by these, as the governor said, as long as you go by these guidelines, you are essential services and you can work. So, yeah. So, and I'm going to show you what these guidelines are in a little bit. So, showing requirements. Property must be sanitized products. You have to have hand sanitizers, disinfecting wipes, face coverings at the property. They need to be available to whoever shows them. I know most listing agents don't do that. During the showing, introduce fresh air. Open windows, open doors. Make sure you're opening cabinets to make sure so people don't have to touch things. Showroom requirement costs. Here's where you can put the cost of these supplies onto your seller. Say that, Mr. Seller, you're going to pay for this. You're going to reimburse me. Cleaning and sanitizing. It's in the guidelines. That property is sanitized prior and following the a showing. So that's easy in a vacant property. You go in, you're opening it up, you wipe it down, it's shown, you wipe it down again before you leave, it's ready to go. Because if you have a lockbox on there, you don't know who's in there in between. But if it's occupied, that's not so easy. But that's the requirement. And then cleaning and sanitizing costs. Broker and agent you know, the seller can authorize you to hire somebody to do this. You know, I don't know. I haven't, you know, that would have been a smart business to get in at the beginning of this. You know, I'm a person, I'll service your listing. You let me know, you know, before and after, and I'll go and I'll do it. You know, there was an opportunity there. So anyways, so then we go into the broker marketing plan. You know what the marketing plan is. We may, you may decide, you know, you're not ready, but we're going to put this on hold. And if we, you know, we're going to withdraw the property from the market temporarily, and then we're going to extend our listing, you know, to compensate for the time that we're withdrawing it. So Section 8 talks about the scope of the broker's duty. You know, it's provide the seller with a copy of the PED forms. You know, the seller, excuse me, assumes all the risks of allowing others to enter the property. The seller releases the broker and its agents from any loss, limited liability, or expense. Additional terms. I don't know what you would really put in this, what you would put in there. Maybe if you wanted to be reimbursed for some other things, you would have those terms in there. So that's the addendum, okay? But also attached to the addendum is, guess what? The PDS, which goes over to this, tells the seller, this is what, you know, this is what the signer is representing, that, you know, I know about, I'm aware of COVID, you know, I haven't been exposed to it to the best of my knowledge. The most important thing is that if you become exposed to it, or you become aware, that you immediately tell the broker, you know, Mr. Seller. I mean, there are a lot of cases where, you know, in the middle of a listing, you know, somebody has gotten sick, and, you know, showings have to be stopped. That has to be reported to anybody who may have been exposed to that property and all of that. So it's very important. Exceptions to representations and additional terms. Well, what are exceptions to representations? Well, what if your client is a doctor in the ER, or a nurse in the ER, or a grocery store worker? Because remember, they've been essential since day one. So they have been exposed to this from day one. So that should go in there. You should be you know, putting that as your exception. So make sure. So the seller signs all that. And here I'm showing you, this is attached to this also, is the BPPP, which are the guidelines. These are the guidelines showing rules for listing and buyer's agents. And number one, I said this morning in our team meeting, the very first showing rule: utilize virtual tours instead of in-person property showings whenever possible. That's the number one thing. The number one guideline was that you needed to do do things virtually, you know, and whenever that's not possible, you're allowed to do in-person showings. So that's why I, as a broker, have tried to instill in everybody, you know, they're asking about open houses and all this. Well, I see XYZ Realty doing it down the street. You know what? We don't want to be that example that gets back to Sacramento and that puts them over the edge and say, look, real estate guys, we gave you a chance. You're not doing it the way it needs to be done. And so we're going to shut you down, because that could happen any minute. So it's really important to know. So we are going to abide by these rules. You know, Also, do not hold traditional open houses. That's still in the guidelines. You know, no open houses, only one listing agent and one buying party. Now, depending on where you're at, like in the city of Los Angeles, buying party is limited to 2 people in the same household. Now, other areas, it's expanded to a buying party. And here's the thing. I had a listing about a month and a half ago, and I was mortified. You know, it happened to be where I was living, where I was renting. My landlord said, I want to sell it. You sell it for me because I was moving out. And I also wanted the listing because I wanted the control as to who was coming into the property. So here I am, the tenant of that property, and I would arrange the showings. And I was appalled by agents who thought nothing of sending me a PED with one buyer on it and then showing up with 3 additional people and thinking that that was all right. It's not all right. And it's not, well, give me the piece of paper, I'll sign it here. It's not that. It all has to be done. It's in these guidelines. Everything has to be done electronically. We don't touch paper anymore. We don't leave flyers at a listing. That's in here. You don't leave flyers at a listing. Deborah, I think you popped on because there's a question.
I do.
Yeah.
Comment. There. You mentioned if you're in Los Angeles. I don't know if you said city or county. It's city, still 2. But for instance,
Right.
I myself showed in Riverside County the other day, and there were about 5 or 6 people that came out of the house. Couple of children and then the adults. So maybe in Riverside County, that would be considered a buying party.
Buying party, right.
I see.
Yes. Yes.
So that's permitted in some
That's
counties.
permitted. Yes.
Is
LA
it
County.
permitted in LA
If it's outside
County?
of LA City, it's permitted. Yes.
Okay.
It's
Okay.
just the city who is more stringent,
Yes.
strict than everybody else. Yeah.
Okay.
So
Cool. Thank
yeah.
you.
Okay. Social distancing is a part of this, that they have to maintain social distancing, not to touch surfaces. That's why you're opening things, for them. It talks about the sanitation products. And it used to be the listing agent was responsible to sanitize every time. That's been changed, that whoever shows the property is responsible for cleaning it. I'm just picking out a little thing, rules for visitors. Basically, this says visitors are going to sign what's the PV, and wear face covering. Excuse me, face coverings. They must wear face coverings for individuals with disabilities who cannot wear a face covering or face shield. The showing agent will engage in an interactive process with the individual to discuss any available reasonable accommodations. Well, you will ask me, what does that mean? And we have all asked, all the brokers up and down the state have asked CAR, what does that mean? And the top legal person at CAR, Gov Hutchinson, says he doesn't know. So, it's basically if you can come to a compromise that works for everybody regarding the face covering. If you can't, then do you say, well, then you can't enter? Well, it's not up to you, it's up to your seller. So you have to give the scenario to your seller and say, look, this person can't wear a mask or something. Whatever. And how do you feel? Do you want to let them in to your property? And if the answer is no, that's when you tell them, I'm sorry, my seller has told me I can't allow you to see it. It's ultimately up to the seller. Okay. So that's the guidelines. Look at the guidelines. It's BPPP. Those are the guidelines. So I'm now going to go back. And I'm going to go back. And I get into this every time. Wait, hold on. All right, hold on. Wait, how do I get it? Wait, sorry. My forms disappears every time when I do this. Hold on. Ah, there we go. So go back to forms, and we're going to go back to COVID. So we've already talked to the best practice. We talked about that. We've talked about the PED-S. I am okay. Before, when you get the listing, there's this thing that must be posted on the door, or on the, close to where somebody enters the property, and it's called the PRE, and it consists of 2 pages. It's the rules, so that everybody entering the property can see, these are the rules when you're in here: social distancing, face cover. A lot of people still say booties. Do not say booties. In the beginning, there was a ton of lawsuits from people slipping and falling. So booties are not required. And I actually, high-end listings, a lot of people have booties, and they make their visitors wear them. Be aware, people fall. It's slippery, especially on those marble floors. That's a lawsuit waiting to happen. Just to let you know. So it's 2 pages, it's words, and it's the pictogram. It also shows it in pictures. So that must be posted on the outside of the listing. So just be aware of that. Okay. The other thing that I wanted to go over as far as a sale, here is the PED-V, which is the PED for any visitor. Anyone who is coming into this property has to fill this out. Anyone. Early on, they were saying, "Oh, the appraiser, this appraiser refuses to sign. They won't sign it." So in that case, you go to, "Hey, Mr. Seller, we have an appraiser of this property, and we have a requirement that they sign a PED-V in order to enter the property, and they're refusing to sign it. What's your decision? What do you want to do about that?" And if the seller says, "Well, if they're not willing to sign it, then I don't want them in my house." And then you go back to your buyer's agent and say, "Seller's instructed me that unless they sign a PV, they're not going to enter the house." And that's within their right. And why is it so important? Because this form basically says that anybody entering the property doesn't feel sick, hasn't been, to their knowledge, been exposed to the corona, to anyone who had tested positive within the last 10 days, hasn't tested positive, all of this stuff. And the most important part is that should your health change within the next few days, you're going to let everybody know, because we have to track this. We have to, there have been people who have visited a property, and then 2 days later they were sick, and they exposed that household to the virus. So it's really important. And then I also want to point out, there is this exception here also. And once again, what's that exception? It's if they are a healthcare worker, if they work in an industry that exposes them to coronavirus, that should go on this form. And and the seller should be made aware, and they should make a decision as to whether they want them to view the house or not. So it's just as simple as that. This confuses everyone, the initial thing, but I want to point out, I acknowledge receipt of a copy of this signed form. The initials below are not required, but can be used as evidence in the initialing party as received the completed form. It's not required. So many buyers agents are saying you need to initial it and send it back. We don't have to do that. If you want to be nice, you can initial it, and so that my office requires it. Well, I'm that broker that I do require some things that other offices don't. So it's nice to be reciprocal. And Deborah, you're back on. Is there a question?
Yes. So Mona's asking, under the notes, can you do not have COVID due to your knowledge? And under my knowledge, they don't have COVID, but I can't be held liable. Or is that extra? So in other words, is it necessary to write that?
No, it's not necessary, because that's by signing this document, you're basically saying, to my knowledge, I don't have COVID. And I haven't been exposed to COVID. That's what the form says.
And nor do my clients.
So right, exactly, yes.
Okay.
So everybody signing it says that, is saying that, yeah.
And I had this question the other day. I just want to make certain I responded correctly. All properties, anyone entering all properties, whether they vacant or occupied, need a PV. Is that correct?
Yeah, that is correct.
Okay.
Anybody entering a property. And then we get this question a lot. It says property addresses up here. I'm showing my client, the buyer, 5 properties. Can I have them sign this and list all the properties? Yes, you can. You could do that. Now, if you're using the great system that Glide has provided inside of the MLS, where you can say, send the listing agent a PV in order to get my client a showing, they won't let you do more than one address. They will generate individual PED forms for every address. But
it's acceptable to have 4 or 5 addresses on that one line. And
yes,
it serves as the one I will take to send to each agent.
Correct.
Okay.
And just be aware that PED form should be signed within 24 hours of viewing that property. If it's not 24 hours, then you have to do another PV. And if your client wants to go back 3 days from now to see it again, you got to do another PV. So just be aware of all that. The other form regarding a sale is the addendum. Nobody really used this, or if they used it, they didn't do it properly. Once you're writing an offer, the coronavirus addendum or an amendment. Why is it called an addendum or an amendment? It's called an addendum if you're just creating the RPA. It's called an amendment if you already have an RPA and you are adding it. So this is the addendum. Once you're in a deal, and basically a lot of people what they would do is they would have this addendum attached. They fill it out. Great, did a great job doing that, filling all that out. Then they didn't do anything for 4, anything for 5, and they signed it. Basically, that does nothing. It's basically telling everybody about coronavirus and that we're aware of coronavirus and blah, 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 blah. So it really did nothing. You really have to either check 4 or 5 in order for this to have any effect. And what does this do? this extends the time frame for a buyer to remove contingencies. You can choose individual contingencies for this to affect, um, or you can extend the close of escrow. So that's what this form was initially made for, because there was so much in the beginning of all this. You couldn't get an inspector, a seller couldn't get a mover. There were so many things, because the county was working remotely. They were really slow, so it was slow to get things recorded. All of these unforeseen things. We were saying, hey, if this happens, and we're going to make arrangements ahead of time that we can extend these contingencies or extend close of escrow in order for us to deal with this. And and if it was used and used right, it's a great tool, because so many people didn't use them, and then they came up with these problems, and then you had to have both sides mutually agree to extend a contingency because somebody couldn't get an inspector, or extend close of escrow. Really, I don't think that right now we're having this problem. And but it's still not a bad form to use, if you want it. 30 days, I think right now 30 days is too much. So maybe 15 days, a couple of weeks, extending things a couple of weeks. If something should come up, you can't get an appraisal done, you finish your inspections, but the one thing that had to happen, is that if you were going to institute this clause, you had to deliver a document called the NUCC, and the notice of coronavirus. I'm going to show you the form, but I can't remember what the last thing was. Notice of unforeseen coronavirus circumstances. That's what NUCC is. So, and it's basically saying, hey, something's happened. It was unforeseen, and I'm giving you this form, and here we are, and I'm instituting this extension. 5 talks about immediate mutual cancellation. So that says the parties agree to cancel the agreement at the time this amendment is signed by all parties, and a copy delivered to each party and authorize it. Buyer's deposit should be returned to the buyer minus any fees and costs incurred by the buyer. This form, CVA, shall constitute irrevocable joint instructions to escrow holder. So if you've agreed up here about the, especially for close of escrow, it says it here, we've agreed to extend by this time because we've been affected by unforeseen circumstances. And then during that time period, you still can't close because of those unforeseen circumstances. That's when you would check the number 5 and say, hey, I took the extra days, I still couldn't do it. We're going to cancel, and Mr. Buyer gets his money back. So that's this form. It really hasn't been used that much, and I've never seen it used really right, to tell you the truth. And then I'll just show you really quickly about the notice of unforeseen.
While you're looking for that, Rich, could I throw a question?
Sure.
Joan Fields Evans said that where to post notice at door of listing in the building where HOA does not allow notices in hallways or on front door.
On the front door.
Just of the unit? She's saying
of the unit, yeah. Of the unit, yeah. Of the unit they're entering, yeah.
Okay, so Joan, if you're hearing that, he's referring to the door of the unit, not the front door of the HOA, the condo.
Right, yeah. Yeah, yes.
Okay. And does,
Um,
my question then would be, does it need to be on the exterior of that door, or could it be inside, right inside the entry?
if it's dangling as soon as they open the doors and it's right in front of their face, then the answer is yes.
Okay.
Otherwise, it should be posted up.
Because I have seen where people have put them in like nice picture frames, have them set on a table. As soon as you open the door, it's right there. You see it's visible with the hand sanitizer and the wipes, etc.
As long as it's, I mean, you cannot miss it,
Got it.
then I would say it would be acceptable.
Okay.
Yes.
Cool.
Okay.
Okay.
This is the notice of unforeseen coronavirus circumstances. If and it names a whole thing, you know, loan related, loss of income, notary delay, and you know anything. You know, home inspection, stay at home. You know, if during the middle of your transaction the there was another stay-at-home order where it was like, okay, nobody's to leave, then you could say that would be a problem with inspections or you know all of that stuff. You know, personal impact. Look, I'm diagnosed with COVID. You know that's something too. So this is to be used in conjunction with the coronavirus addendum to or an amendment to the RPA. So now let's in the 15 minutes I have, which I know that I'm not going to go through this, but the leases. So you see what I did? I switched from sales to leases. I won't go over the PEDs. I will just say that there is a different PED. It's the PED LR, which is for the owner of the lease to sign and the tenant to sign. They both need to sign the PED LR. If once again, if the tenant doesn't sign it, as in the case of the PED-V, then nobody gets to go into that. I had a question. It's the same postings also on the outside of the property. You know, the same things that Deborah and I were just talking about. So you still need to do that. I had a question about this form, the notice to tenant of COVID-19 Tenant Relief Act. You know, there was a Tenant Relief Act that was put into effect. I can't remember when it was. This form was February, so it was probably close to February, and it basically says there's two different like I don't know how I want to say it. This all started March of 2020. So if you, Mr. Tenant, didn't pay because of you were affected by coronavirus between March 1st, 2020 and June 30th of 2020, you have some rights. It talks about the law gives you, if you failed to make payments between March 1st through August 31st because you had decreased income, as described, you may be unable to make rental payments. But starting September 1st through June 30th of 2021, the tenant is responsible to pay at least 25% of the rental payment. So it's not that from June 30th forward or back to March 1st, the rent is forgiven. You still owe that rent to the landlord. But now we're dealing with a different time frame, and on that second time frame, you have to pay at least 25%. If you don't, if you don't pay 25%, then the landlord can give you a 15-day notice to pay or quit, and can start eviction proceedings, theoretically. I say this theoretically because I don't think anybody has kind of taken this up, and there's so many different things about it. But according to this Relief Act, that if the tenant doesn't pay the 25%, then they can be evicted. But do they have to pay the 25% starting September 1st, 2020? The answer is no. That really isn't due until July 1st, 2021. So they have until July 1st of 2021 to pay 25% of the rent owed between September 1st, 2020 to June 30th, 2021. This is all very confusing. Nobody really knows exactly what's going on, because depending on where the property is, there are different rules. There is a different time frame as to how long they have to pay it. Everywhere except LA City gives 3 months to pay this money. LA City gives you a year. So basically, we're not going to have a real handle on evictions or rent owed or any of that, at least probably for another year, I would say. Now, part of this act is that there is assistance available to landlords, which I sent out an email a while back, like a day or so ago, giving you a link as to where these landlords can apply. I got some emails back from several agents saying that some cities aren't really ready. It all depends on what city the property is in, and some cities aren't ready. I think Eric Green emailed me that he has a property in Palm Springs, and he was able to put in an application there, but he has another property somewhere else, but they weren't ready. I think Long Beach isn't ready, but they are ramping up. There is assistance available, but it's very specific as to who qualifies. So I'm not going to go over who qualifies. I included a Q&A in my email, so hopefully that clears some things up. But once again, I'm going to say this, I can't say this enough. When dealing with tenant landlord issues, absolutely don't counsel your clients. Suggest they talk to an attorney, because it is. I was in a meeting this past Monday with Dennis Block, who is the #1 real estate eviction attorney in Los Angeles and Orange County, I believe. And he says it is so confusing because there are so many different factors. So if that guy can't figure it out, then you shouldn't be trying to figure it out. So I just say that because there will be a lot of lawsuits, trust me, in regards to this. Let's see. Um, there is a form here. There are unpaid rent calculations agreements. There's like a cash for keys kind of one. I would just go down and kind of look at them. If you have questions, I can answer them individually. It's going to take me a lot of time to go over these lease ones, and like I said, I wouldn't get involved. um, so anyway, I think I'm gonna. Deborah, are there any questions? Because I think this is a good place to kind of. We went over the sales side, and I think that's a good place to end
Not
it.
seeing any questions right now. We'll give one last shout out. So in case they have any,
Okay.
please put them in the comments now on Facebook and we'll go from there. We had a real nice turnout. No,
Oh, good.
looks like we're good.
All right. Well, I appreciate it. It's like I said, we'll probably be with this for another few months, assuming that the trends are still going where they're going. More people are getting vaccinated, and it's getting better, I believe. And vaccinations are being made available to more people. So whatever your stand on vaccinations are, it's your own personal choice. I encourage you to stay healthy. So whatever that means for you, I will say do it. Okay. So thank you, Deborah, and thank you, everybody, and we will call it a day till the next time. All right, take care.
Thank you, appreciate it, and appreciate everybody's attendance. And they all said thank you, Rich. We have.
All right, thank you.
All right, take care, guys. See you next time.